It's always something that unsettles me. You know, seeing the woman screaming, the doctor rushing in, and it's like this image we've come to expect, this stereotype of how birth is shown in film. There's this cinematic version of it, and yet, despite that, it's still something beautiful because it's about bringing life into the world. For my wife and me, our experience with birth was beautiful, even though it came with pain. My wife was in labor for 36 hours. So, I really wanted that birth scene to reflect a sense of realism and beauty. Hi friends, welcome back to my channel. I'm really struggling with this case involving Blake Lively and Ryan Reynolds, along with these PR agents. If there's anything I've learned from this case, it's that some of these PR representatives are among the most deceitful people you could imagine. I can't even fathom being part of an industry that is literally built on helping individuals like Blake and Ryan, or others like the Duggars or Cody Brown, people I consider terrible. Let's not forget that even Leslie was Harvey Weinstein's publicist. These are people whose job is to promote flattering stories while suppressing the negative ones. And Blake and Ryan have significant financial means to keep stories hidden. Leslie Sloane holds considerable sway and works tirelessly to manage the media narrative, burying any unfavorable coverage of her clients. And for many years, that tactic worked incredibly well for Blake and Ryan. We hardly saw any bad press about them. But now, that facade is cracking because the courts are revealing the truth. Leslie Sloane filed a motion to compel Justin Baldoni to produce documents and to require him to respond to interrogatories. This motion feels calculated. It seems early. We're just 2 weeks past the date when the interrogatories and document production requests were issued. After receiving these requests, there's an opportunity to object. Once objections are filed, both parties are supposed to meet and confer, working through their disagreements before escalating the matter to the court. From my own legal experiences, having dealt with multiple lawsuits, I've seen firsthand that judges don't like to get involved in motions to compel unless it's absolutely necessary. They also don't rush to issue sanctions, especially if it appears that not enough effort has been made to resolve issues independently. A judge might say, "You haven't spent sufficient time negotiating this. You've come to me too soon." In that case, they're unlikely to compel anything, and sanctions probably won't be applied. Not to Justin, not to Wayfair. That's what I've encountered. I've gone through discovery that dragged on for over 2 years and still didn't receive all the documents I needed for my case. So, when I see her filing this motion to compel only 2 weeks in, knowing that the discovery deadline is August 14th, it reads as a strategic move. It gives her the chance to publicize her demands, to cast Justin in a negative light, and to make accusations against Melissa Nathan. They accuse Stephanie Jones of wiretapping, and now this feels like part of a larger strategy, not just legally, but publicly. It seems designed to get the judge's attention before a decision is made on the motion to dismiss. They're trying to signal to the judge, "Look, they don't have real evidence. Please see this as proof." And at the same time, it's a move to further damage his image in the media. In the letter attached to the motion, their attorneys write, "After 4 months of dissembling and issuing vague and inconsistent statements through their attorneys, the Wayfair parties have yet to identify the basis for their claims against the Sloane parties, including but not limited to the statements they claim defamed them or placed them in a false light, when or how those statements occurred, and to whom those statements were made." But that's just not accurate. It's in the documentation. It's in the complaint. She contacted the Daily Mail and began feeding them a series of stories. There are text messages from the Daily Mail journalist who received that tip directly from Leslie Sloane. The texts detail what she claimed was happening on set, and it was Leslie who was pushing that information out. She knows what she did. It's unbelievable that this is even up for debate. Back to the filing. According to Sloane's motion to dismiss, they claim the Wayfair parties were obligated, but failed, to provide that information in the complaint. But they weren't required to. The opposition brief from Wayfair doesn't go into added detail, stating only that they know and allege Sloane made statements to reporters, referring to Baldoni as a sexual predator and accusing him of sexual assault, and that she seeded false stories about him in the Daily Mail to deflect attention away from Blake Lively. And somehow, the Wayfair team made those factual claims even after citing, In their now-dismissed California lawsuit against the New York Times, a screenshot of a Daily Mail reporter admitting to Brian Friedman and Melissa Nathan, "I had many conversations with Sloane about Blake, and never once did she mention sexual assault." Sloane denies ever referring to Baldoni as a predator or accusing him of sexual assault. Because of that, she claims she can't defend herself properly without knowing exactly what she's accused of saying and to whom. That entire statement, to me, as someone who's been through litigation, feels like an attempt to jog the judge's memory. She's reminding the court, "Hey, remember my motion to dismiss? I filed it a while ago, and I made some really great points in it. Just want to remind you, they don't have evidence. I didn't say these things. They can't prove what I supposedly said or who I said it to. And by the way, I had a really strong argument in that motion." It's a tactic. She's trying to steer the court back to that still pending decision. But Leslie, let's be honest. I've been waiting 4 months for a summary judgment decision in Minnesota. Be patient, it takes time. This is all part of a broader strategy. She's using small footnotes, and honestly, if those were real, substantive claims, they wouldn't be relegated to footnotes.
It's just a way to take jabs.
One message, still not produced by the Wayfair team, claims Melissa Nathan coincidentally overheard Sloane's phone calls, which would violate California's wiretapping law, Penal Code 631. The Daily Mail journalist says, "I had a 3-way call with her and Melissa, and she never said anything about that then either." But Sloane insists that no such 3-way call happened, at least not one she was aware of. That suggests either the Daily Mail reporter or Melissa added someone into a private call without Sloane's consent. Leslie Sloane has known about that screenshot for months. The only reason she's bringing it up now is because they're making accusations against Stephanie Jones for intercepting messages, something they actually did illegally on Jenny's phone. Now, they're trying to shift the blame onto Melissa Nathan, claiming she's the real wiretapper. I also suspect that even though Leslie has her own legal team, a lot of this is being pushed by Ryan Reynolds. All of this seems driven by Blake and Ryan. They want to present themselves as the victims, trying to get ahead of the judge by saying, "Yes, we're being accused of wiretapping, but they did it, not us." But that's not how it works. If the claim were legitimate, Leslie would be filing charges, but she's not. Instead, in my opinion, she's using it as a smear tactic, hiding behind litigation privilege. It's like, "Oh, they accused us, so now we'll accuse them." We already know that Leslie was involved in obtaining documents that were illegally discovered. Stephanie Jones wasn't supposed to give out those private messages, but she did, and Leslie was a recipient of information she wasn't authorized to have. Now, she's trying to deflect and blame Melissa for being the wiretapper. It's painfully obvious, and I believe the judge will see through this strategy. Leslie then argues that the Wayfair parties have a Rule 11 basis for their claims, and that they should be forced to make admissions instead of hiding behind vague objections to proper discovery requests. The whole thing about boilerplate objections? That's a standard part of the discovery process. You're allowed to raise typical objections and use standard legal language in discovery. But here, the boilerplate stuff is important because they're essentially admitting they used a boilerplate lawsuit to unlawfully obtain records from Jen Abel's phone. Now, Stephanie is facing serious charges: wiretapping, computer fraud, and violating data storage laws under federal regulations. It's a big deal. So once again, they're flipping the narrative. This is what PR agents do. They try to change the story. Leslie's apparently claiming that Interrogatory 3, which asks them to identify each person Sloane allegedly communicated with regarding the Wayfair parties, is a problem. But they've already identified at least a couple of people. The reason this interrogatory is important is clear, especially since the Wayfair parties are making claims about defamation and false light based on conversations they can't even identify, who was involved, when it happened, or what was said. This would only be a valid argument if they didn't have actual text messages from the Daily Mail journalist, which detail everything he discussed with Leslie. Once again, Leslie is trying to make the judge think that there's no evidence. They're objecting under Rule 33.3, but even if that objection hasn't been waived, Interrogatory 3 fits squarely within the scope of Rule 33.3, which allows for requests that seek, among other things, the names of witnesses with knowledge of relevant information, and details that can help target future discovery efforts. Without more information, the Sloane parties can't even assess which of the over 150 individuals and entities listed in their initial disclosures might have relevant knowledge to the case. It's just silly. Leslie knows exactly who she spoke to. She knows which journalists she contacted, which outlets she tipped off, and where she gave information. For her to pretend she doesn't know is absurd. She probably has all of it in her emails. She's likely even handing over her own discovery documents to the other side. So, this could also be her attempt to get ahead of it, acting like, I don't have this information, when she clearly knows who she talked to. They also objected to interrogatories 4, 5, and 7, calling them meritless. These interrogatories are about identifying the malicious stories that portrayed Baldoni as a sexual predator, as mentioned in paragraph 8 of the amended complaint, and identifying each story critical of him, including the one about him being a sexual predator ahead of the film's release, as described in paragraph 282. They didn't respond to these questions because they simply can't. Instead, they said they would narrow interrogatory 3 by adding the language, to the extent those communications are relevant to the claims and defenses of actions. Their only defense for using Rule 33.3 is that the Sloane parties used similar objections. Then Leslie said, during the meet and confer, counsel could not even confirm whether the Wayfair parties are alleging that Miss Sloane used the term sexual predator or sexual assault in reference to Baldoni. The irony here is that Leslie herself used these terms in her motion to dismiss, claiming that Blake's allegations were sexual assault. It's just a bunch of word salad at this point. What this all boils down to is that Leslie wants to know which articles are considered defamatory or otherwise actionable. She argued that, given the level of publicity surrounding this dispute and the number of articles written about it over the past year, it would be impossible to complete discovery into the allegedly defamatory articles without a clear list of what's being claimed as defamatory. Simply put, the Sloane parties need a basic roadmap of the claims against them so they can prepare their defense and focus discovery properly. Leslie's response to interrogatories 4, 5, and 7 is that interrogatories are more practical than depositions because they seek straightforward answers rather than long, narrative explanations. She's asking the court that, if the interrogatories exceed the scope of Rule 33.3, they be allowed to serve amended ones under the local civil code rules. On the other hand, the Wayfair parties are objecting, claiming that the interrogatories are too broad, don't narrow the scope enough, and violate the relevant codes. They're saying, if you're right, we'll amend them, but we want the court's permission to do so. At the same time, Leslie is asking the court to compel the Wayfair parties to produce documents in response to request for production number 32, which asks for documents they intend to rely on when drafting a further amended complaint. This includes the documents referenced in their March 6, 2025 brief in opposition to Sloane and Vision PR's motion to dismiss. The Wayfair parties have repeatedly claimed, both in filings and in the media, that they have obtained additional information about the Sloane party's activities that they plan to include. If, as the Sloane party suspect, the Wayfair party's claims to the court and the media are false and they have no additional evidence against the Sloanes, they should just admit it. However, I believe a judge will likely deem this part of the case premature. First, unless they file an amended complaint, they're not obligated to give Leslie any evidence of additional claims. They've stated that if they need to amend, they will do so and will provide any new information they have. But at this point, they're not required to disclose everything, especially not their most compelling evidence. A lot of this seems like Leslie is trying to force them into a position where they have to put up or shut up now. It's a desperate attempt to get out of the lawsuit. Leslie is essentially asking the judge to say, please grant my motion to dismiss, make them either prove their case or drop it. But the judge can't do that just yet. Leslie is also asking the judge to compel the Wayfair parties to give her this information, or else. And if they're wrong, she's requesting that the court allow them to amend or reserve their requests. Now, I want to show you just how hypocritical her requests are, considering what she's asking them to produce. The Wayfair parties have actually given a production document in response to some of the requests, but some of these requests are downright offensive. To start, Leslie keeps saying she never called Baldoni a sexual predator, and she never claimed anyone was sexually assaulted. But when they responded to her objections, they raised basic issues like admissibility, relevance, and the fact that some of the information being asked for either doesn't exist or is protected by attorney-client privilege. There were several objections right from the start, with the responding parties saying that some of the requests were irrelevant, overly broad, unduly burdensome, and disproportionate to the needs of a case. For example, Leslie asked for documents from January 1st, 2019 to the present. But didn't the alleged smear campaign start in August? And didn't the judge already rule that they couldn't ask for information prior to August? So why would she need documents from January 1st, 2019, before Blake was involved in this matter? Among the things Leslie requested were all documents concerning Leslie Sloane and all documents concerning Vision PR. The Wayfair parties objected to these requests for a variety of reasons, but said they would produce what they have, provided those documents aren't protected by privilege. They also objected to requests for all documents related to allegations of sexually explicit or inappropriate actions, conduct, or comments made by Baldoni, Heath, or anyone else during the film production. What does that even mean? The request is too vague, and it also asks for trade secrets, attorney-client communications, and work product, which are protected. They said they would provide some documents, but not all. One of the more troubling requests was for all informal or formal complaints or discussions about the work environment on set, including anything related to the lively Reynolds parties. They responded by saying they would produce some documents, but objected to most communications concerning complaints about Baldoni or Heath in any employment setting, at any time. Leslie's requests are overly broad, and it seems to me she's just trying to drown him in paperwork. My opinion? She's frustrated about being sued and brought into this, so she's using discovery as a tool to be petty, demanding everything in sight to overwhelm him with documents. For instance, she's asking for all documents concerning allegations of sexual harassment, sexual assault, or unwanted sexual contact by Baldoni or Heath at any point in time. But didn't she just say he wasn't a sexual predator? Now she's demanding all documents related to these types of allegations. He's refusing to search for such documents because he's never sexually harassed anyone, so he says he simply doesn't have them. Then, she wants all documents, contracts, or agreements with public relations firms, marketing agencies, and other third-party providers of social media services, including efforts to influence or manipulate social media algorithms or boost content. Baldoni responds that he didn't do these things, so he won't provide any documents related to it, as it would violate multiple legal protections. She also wants all documents and actions taken to harm the lively Reynolds parties, Sloane, or Vision PR and damage their public image. This request is bizarre and vague. She's the defendant, not the plaintiff, so she doesn't need this information. Baldoni objects, saying he didn't take any action to harm their public image, so he can't provide documents related to that. Leslie asks if he paid for negative content or solicited others to post negative material. He responds by saying he didn't do that and has no documents to hand over since it didn't happen. She also requests documents regarding bot services, to which he objects again, asserting that he didn't use bots and therefore has no documents to provide on that. She keeps asking about communications with media outlets encouraging negative posts or articles about the lively parties, Sloane, or Vision PR. Baldoni continues to dispute the claim, saying he never communicated with any media outlets to encourage negative content. This is a typical strategy where Leslie lays out all these negative allegations, knowing it's impossible to prove a negative. So, Baldoni's response is straightforward. He doesn't have documents because he didn't do what she's accusing him of. She also wants documents concerning communications with cast, crew, or employees of the lively Reynolds parties, as well as any attempts to gather negative information about them. He disputes this as well, saying he didn't do it and has no documents related to it. Finally, she's asking for any attempt to hide or divert attention from inappropriate or harassing behavior on set related to the film. Baldoni objects to this request too, as he disputes that any inappropriate or harassing behavior occurred. This is just typical narcissistic behavior, throwing out outrageous accusations that can't be proven, knowing it's impossible to prove a negative. Leslie keeps asking for documents related to formal or informal complaints about a hostile work environment, but Baldoni has objected. He's also refusing to hand over documents regarding any feuds or disputes between the Lively Reynolds parties or any Wayfair party regarding aspects like filming, editing, or marketing of the film. He's not searching for these documents because doing so would infringe on third-party privacy rights, and many of them are not even in his possession or control. Now, Leslie's trying to claim there was a smear campaign against her, but Baldoni disputes that he was involved in any negative media or social media campaigns against her, or anyone else. She then requests all documents related to strategies to conceal information, and documents and communications concerning Baldoni allegedly discussing his porn addiction with Lively. Baldoni disputes this, stating under oath that he never had that conversation with her. She continues asking for documents concerning him entering Lively's trailer without her consent, but Baldoni again denies this and says he won't search for such documents. Then, there are further demands about documents related to improvising scenes, particularly sexual or kissing scenes in the film, but Baldoni denies this ever happened, so he won't look for those documents. Next, she demands documents and communications about him having sexual conduct with a third party without Lively's consent. This is just absurd. It's clear she's trying to humiliate him and make him out to be a predator. Baldoni denies this claim as well and says it's irrelevant to the case, so there's no need for him to search for any related documents. Leslie also wants documents identifying participants in the text messages mentioned in the amended complaint. Baldoni says he doesn't have those either, and lastly, she wants documents that Baldoni intends to rely on in drafting a further amended complaint. Baldoni objects to this, citing attorney-client privilege and the work product doctrine, and he argues it's premature since no amended complaint has been filed yet. It's clear that Leslie's motion to compel is focused on what might implicate her down the line. She's not really trying to fight Baldoni's objections regarding the sexual assault or harassment claims, or even the smear campaign allegations. She's only trying to get the court to intervene to force Baldoni to produce documents that could impact her defense in the future. She probably fears what evidence they may have against her. She's only asking the court to intervene on the documents that could impact her, not on any of the obscene requests she's made regarding sexual assault or harassment, things Baldoni has already objected to. So, Leslie's acting like she doesn't care if Baldoni didn't harass anyone, didn't run a smear campaign, didn't use bots, or didn't engage in any harassment toward Lively. But she's really only focused on what he has on her, and that's what she's panicking about. The only thing she's asking the judge to intervene on is what evidence he has on her, which makes it clear she's more concerned about her own situation than anything else. I highly suspect that Wayfair has substantial evidence against her, but she's trying to act like they don't. In this entire case, the only ones proven to have lied so far are Leslie Sloane, Blake Lively, Ryan Reynolds, and Stephanie Jones. Wayfair has provided all the receipts, and Leslie's strategy is all about getting ahead of the judge and trying to manipulate the situation. She's trying to flip the narrative by asking for documents like, "Hey, I know you didn't do this, but give me the evidence that proves you didn't." Then she turns around, deflects with all this PR spin regarding the illegal subpoena and Sham lawsuit, trying to shift attention back onto Baldoni. But Melissa Nathan is not Justin Baldoni, so the allegations against her don't even make sense. Honestly, it's frustrating because I hate to see Baldoni dragged into this mess, especially when he's on the receiving end of what looks like a harassment lawsuit against narcissists who have no remorse and don't care about the truth. The process will likely be long and exhausting, and all of Leslie's requests for interrogatories and documents seem designed to overwhelm and fatigue him, hoping to get him to drop the case. It's clear she's trying to play the PR game, and if she can't get the judge to dismiss the case, she'll try to wear him down with constant filings. This motion to compel is just another example of how they will abuse the court system to paint Baldoni in a bad light, all in an effort to win the public relations battle. But, again, that's just my opinion. I'd love to know what you think, though. If you enjoyed this video, please give it a thumbs up, subscribe, and hit the bell so you never miss a video. Thanks for watching.